Hey everybody, thank you for joining our first webinar of the year. And the topic today is around 2025 compliance and preparedness. And so uh, really quick, just want to introduce myself. My name is Lawrence Leung. I'm going to be the host for today. And I am one of the co-founders of Kia. Been doing this for a number of years, upwards of 30 years, both property management as well as real estate sales and purchasing. And so over that time, Kiop has done an incredible job of curating really great industry leaders. And today we have one of those with us, somebody that we have and have worked closely with over a number of years, both personally and professionally. And I want to introduce him to you today because he will be our speaker. So Justin Goodman, uh, lawyer, landlord attorney extraordinaire. He not only is on a number of panels that I regularly attend, both at the San Francisco Apartment Association level, but also with a lot of property management and landlord professional associations as well. So Justin, can you say a few words about yourself?
Sure. Thank you for the introduction. And I love talking about myself, but I want to talk about you guys first. I think you're right. I think we must have met with you as a client first, but we've been working together for many years with you and Melanie, and of course, the whole team. I very much appreciate your commitment to industry excellence. We are all in this together. Brokers, property managers, attorneys, property owners of different shapes and sizes. And if we are all doing our job correctly, hopefully nothing erupts into litigation. And that's part of what today is about. Obviously, civil litigation is my practice area, but I'm just as happy to see people never get into trouble in the first place. And so a lot of what you and I both do, I think, is making sure that our clients understand what the law is and where the mines in the minefield are and how to stay on the safe side. I've been doing San Francisco landlord tenant law, among other things, for over a decade. I love the city. I'm a California native, born in Los Angeles, but really couldn't wait to get up here after law school. And I dove into San Francisco landlord tenant law. I've had the benefit of a lot of really great mentors in generations that preceded me. I've tried to learn everything they have to offer. But of course, this industry is changing all the time. We're talking about some changes to 2025 law today, and we're expecting more throughout the calendar year for next year. My practice, again, focuses mostly on San Francisco landlord tenant law. I have a lot of work that deals with the interplay between state and local law. So that's your Costa-Hawkins Rental Housing Act exemptions, rent increases, things like that, or non-fault evictions, particularly the Ellis Act, which is when San Francisco regulations are too much and you just want to occupy your own property or sell it to someone who's going to move into their home and you need to exit the rental market. That's a big part of my practice. And it is a second full-time job just keeping up with all the changes in law. So thank you for having me today, and I'm looking forward to talking about it.
Thank you, Justin. And just a little housekeeping stuff. Um, we are obviously, as I mentioned earlier, covering 2025 compliance. The timing couldn't be any better. Usually at the beginning of the year is when a lot of new laws come into place. For the format of this discussion, Justin and I are going to have more of a casual conversation. You don't need to take notes, but you're more than welcome to. We will be providing the slide deck to you afterwards, which covers a lot of the information that we'll be talking about today. While we go through the conversation, if you have any questions, please click on the Q&A at the bottom, add the question to the queue, and then we'll try to get to the questions at the very end, or if it makes sense, we'll try to answer some of the questions during the conversation. Lastly, just reemphasizing what Justin said, it really is not about property management. It's not about landlording. It really is about risk management. It's about making sure we're mitigating your risk and liability. And the best way to do that is for you to understand the laws that are out there. And in a progressive city like San Francisco and California, there's always laws that are changing all the time. And you'll see it here today. So as we get into the conversation, what we'll do is we'll try and catch you guys up with some significant things that changed in 2024. And then more specifically, stepping into some things that changed in 2025 that also were relevant for 2024, and then dive full deep into all the things that changed in 2025. All right. So to start off with, one of the most onerous things that we ended up having to deal with as a property management company, I'm sure a lot of landlords and self-managing property owners felt this as well, was that 10-day notice. Before you could even do any type of cure or quit or pay or quit, there was this requirement that the city had that, hey, you have to let the resident know that they have 10 days warning to try and cure or correct something before we can even go through the process of doing a formal cure or quit or pay or quit notice. I'm glad to say, based on great work by the firm that Justin's with, they were able to fight this and get that overturned. And so I want Justin to just touch on it a little bit, bring us up to speed with what happened, and give you guys a little bit more information on this.
Thank you, Lawrence. So generally speaking, this regulation makes most sense in the context of state and local law. The state unlawful detainer procedures have existed for since the mid-19th century. And the idea is if you have a tenant on your property, they're not paying their rent, but you still have to pay the bank, you need them out quickly. Back in the 19th century, they were trying to solve the problem of what was called self-help evictions, which is a polite way of saying you physically drag someone off your property or threaten them with violence and recover possession that way. That is a no-no. There's a policy in the state of California that we don't do that. And so they enacted the unlawful detainer statutes as really the fastest kind of civil litigation. The summons is shorter than a regular summons. You get trial setting within 20 days of a request instead of whenever the presiding judge finds a trial date for you. They're designed to move quickly on the pace of months rather than years, and you're supposed to get the tenant out. All those procedures are set at the state level, but for about 5 decades now, the Supreme Court of California has recognized that cities have the authority to regulate the substantive grounds for eviction. Now, we're in a housing crisis, politically speaking. State and local governments really want residential tenancies kind of to exist in perpetuity unless something goes wrong. When something goes wrong, a landlord is entitled to avail themselves of state law, state procedural law under the unlawful detainer statutes. And that is, among other things, that 3-day notice to pay rent or quit. That is like the quintessential notice that you guys all know about. San Francisco, politically speaking, would love to help preserve affordable housing by obstruction if they can't stop it outright. They cannot eliminate the ability to evict for non-payment of rent, but what if it takes 10 days instead of just 3 days? So they injected this 10-day notice to cure in front of the 3-day notice to quit. And now all of a sudden we're like at the end of the month when they owed rent at the first, and it's just more and more delay. And if this was permitted, well, can it really just be only 10 days? Could it be 30 days? There are other jurisdictions that have enacted laws where you have to owe a certain minimum amount of rent before it's considered in default. So local governments try to play games with all of this stuff, but at the end of the day, if it is talking about timing, if it's talking about procedure and your access to the courts under state procedural law, that is the purview of California, and San Francisco has no authority to regulate. So that's what the lawsuit was about. We were successful both. Well, we had sort of mixed results at the trial court level, but the Court of Appeals saw it the way we did, struck the ordinance in its entirety. So for now, we're just back to the same evergreen rules that you guys all know. For fault-based evictions, it's usually some kind of 3-day notice to cure or quit before you file your lawsuit.
So happy when that finally was struck down, and back to, like you said, normal par for the course. We're able to issue a cure or quit or a pay or quit whenever we need to.
Yep.
Another thing that changed significantly last year was related to the November elections. And so every single year, we always have something that comes up on the ballot. And this past year was no different. Prop 33 and Prop 34 popped up. And for a lot of people, they didn't realize how impactful this was. The risk of overturning Costa-Hawkins, which is one of the best landlord laws that we have that help protect a lot of the rights that we have as property owners. And so there was a big push to try to advocate for not overturning it and voting no on 33 and yes on 34. If you could give a little color as to why that was so important, Justin, and why everybody should be breathing a huge sigh of relief that we were able to save Costa-Hawkins, that'd be great.
Sure. And I feel like I always want to start with a history lesson. So if that's all right, up until the late 70s, there wasn't really any local eviction rent control. And then these ordinances started popping up to, so, I mean, how long have we been in a housing crisis now? We're up to the second generation in a row. So these were local regulations designed to keep rents more or less where they're at. Some cities got it totally wrong out of the gate. Berkeley's an example. They just tried to set the rate where it was, and that was the rate forever. And the Supreme Court of California found that that did not allow the rental rate to grow with the rate of inflation. So your net operating income was actually shrinking over time. That was constitutionally prohibited. That's a taking. But then rent ordinances started getting it right. You have to allow it to increase by some CPI adjusted rate. That's what we do in San Francisco. So that's constitutionally fine. But by the mid 90s, there were 5 California cities that were imposing what was called strict rent control back then, compared to moderate. So moderate is what you know now. It's the tenant is rent controlled, assuming the property is. They're rent controlled while they remain a tenant. And as soon as they vacate, the unit decontrols. The rent controlled rate, with some exceptions, maybe we'll get into today with some exceptions, the rental rate doesn't follow the unit, it follows the tenant. So you can charge market rate rent as long as there is a fault-based eviction or voluntary vacate. But in the strict jurisdictions, I think it was Berkeley, Santa Monica, West Hollywood, East Palo Alto, and Cotati, those cities had the strict ordinances where if the tenant vacated, the rental rate stuck with the unit. Costa-Hawkins was a reaction to that at the state level. Property owners and associations were afraid that this strict species was going to infiltrate San Francisco and other jurisdictions. The Costa-Hawkins Rental Housing Act does a lot of things. For instance, it exempts new construction, single-family homes and condos in a lot of cases. But most importantly, for larger portfolios, property managers who want to see the rents grow over time when tenants move on, it preserves vacancy decontrol. When a tenant voluntarily vacates, you get to charge market rate rent, whatever that will bear. Proposition 33 was the most recent effort. There have been 3 ballot initiatives, I think, in the last, I want to say 6-7 years. There's been another attempt to do it legislatively, but the ballot initiatives were all sponsored by an individual named Michael Weinstein, who is president of the AIDS Healthcare Foundation down in Los Angeles. And his purview really is servicing the community of people who are suffering with AIDS, HIV. He has a organization that offers them medication that they need and at a discount. And he also owns, or the foundation owns and operates certain low-income properties that, among other things, cater to that community. But while charging the discounted rate for the medication, he is technically still making a profit. And one of his pet projects with that, I'm going to call it a slush fund, has been to attack Costa-Hawkins. I think because of the remote connection it might have to keeping housing affordable for certain kinds of tenants. It's just something he has been laser focused on. So all of these legislative efforts, it was Prop 10 in, I think, 2019, Prop 21 a couple of years later, and then this one, Prop 33, they were all him. This most recent one was the most alarming because it's one thing to repeal Costa-Hawkins. If you do that, then I guess the city can operate within its health and safety authority, its police power at the local level, and that includes rent control. But because this was a ballot initiative, it means it needs another ballot initiative essentially to undo it. And this particular one wouldn't have just repealed Costa-Hawkins. It would have asserted the primacy of a city to operate in the field of rent control essentially over the authority of California to preempt it, which means it couldn't have been fixed legislatively. So this was terrifying. And I don't think a lot of voters understood that. It's not a very sexy issue to talk about state law preemption and ballot rules and election law. But fortunately, they understood it intuitively enough to know that it was not the right thing to do for small property owners. Maybe some of them felt that it protected a certain class of incumbent long-term rent-controlled tenants, but really excluded younger, newer tenants from the party and didn't really solve the housing crisis. It just overregulated a specific aspect of it. So fortunately, as Lawrence said, Prop 33 failed. It was on the same ballot as Prop 34, which is interesting. This was a completely separate ballot initiative that would prevent owner-operators of multi-unit housing from putting things on a ballot if they had a long list of notices of violation that they were not curing. And Michael Weinstein felt personally attacked by this because he would certainly be barred from it. That proposition passed as well. And so seemingly this will be the end of his efforts to do this at the ballot. I certainly think that honest minds could get together and point out some things in Costa-Hawkins, maybe that could change. For instance, San Francisco, as part of its fray in the mayoral campaign, then President Aaron Peskin sponsored a local ordinance that would change the new construction date. Currently, it is June 13, 1979. He would have changed it to November 5th, 2024. So anything built before that date with a certificate of occupancy issued before that date would not be considered new construction, even though clearly it was. But that the compromise deal, he was doing that, I think, to force London Breed to take a position against rent control and hurt her at the ballot. But a compromise version of the legislation put the date at 1994. And I think there's a logic to that. Now, because 33 didn't pass, this law is irrelevant, but it's technically on the books. It's a trigger law. But I don't think there's a problem saying that anything built before 1994 should be subject to the rent ordinance on the logic that the developer already got their return on investment for new construction. I think you could make that tweak, but I think that that should happen at the legislative realm and with input from the California Apartment Association and other industry experts, not just at the ballot box with a confusing ordinance. So I think we are overall very happy with what happened in this last election for this industry. We all breathed a collective sigh of relief. And for now, Costa-Hawkins is alive and well.
Yes, it absolutely is. And I think that helps catch up, at least with the biggest news that happened in 2024. And so if we look forward to 2025, there was one thing that did change significantly in 2025 around security deposits. But there was also something that changed in 2024 around security deposits, and that's AB 12. And for a lot of property owners, they may not have noticed this change, but it was a significant change because it really capped the limit as to how much you can request for security deposit. For us personally at KIOP, we maximized the amount, and at the state level, they allowed 2 months, 3 months if it was furnished, but 2 months unfurnished. And so that's what we requested. Now, effective July 1st of 2024, that limit came all the way down to just 1 month. And so that's a law that changed last year. I'll let Justin chime in if he wants to on his thoughts around that. And then we'll jump into all the other security deposit changes that changed in 2025 that are really meaningful for a lot of self-managed properties, as well as landlords, small landlords out there, because they are going to impact how you handle those security deposits.
So yeah, generally speaking, and I'm constantly reminded of this when I'm approaching problems analytically, a landlord-tenant relationship is a contract, and it is generally interpreted under the laws that affect contracts. So if someone breaches a contract, the non-breaching party has a remedy. When we're talking about security deposit, what we're really thinking of is what happens if the tenant breaches the lease. They do damage to a property in excess of normal wear and tear. That wear and tear standard is important here because if someone is living in a property and using it and walking on the carpet that becomes threadbare over time, and they're cleaning the walls to get the dust off, and so the paint gets a little bit beaten up over the years, or the laminate countertop starts losing its patina. So things need to be updated over time. Things just wear out. That's not something that the landlord can get relief from in terms of the tenant breaching the lease. That's just something you renovate the unit over time. You can expense it, you can depreciate it. That's just cost of doing business. If the tenant damages the property, you can sue the tenant. So the idea of a security deposit here is it shortcuts that. This is all done by state statute, and the state statute wants to balance the competing interests of the landlord to be made whole and to have this sort of self-executing relief fund so they don't have to file that lawsuit, while also protecting the tenant's interest, because this is not a source of extra profit for the landlord. It is not a fund they can dip into to offset the expenses of renovating or updating a unit. It is only to make the landlord whole if the tenant is in default in the payment of rent, or they've done some kind of damage to the property above normal wear and tear. I think responding probably to I'm assuming anecdotes. I don't know how much data gets collected at Sacramento on this, but probably anecdotes over tenants feeling that their landlords took advantage of them. And these are, a couple $1,000 maybe, perhaps not something big enough to bring a lawsuit over. So Sacramento steps in and they regulate this to make it more protective to the tenants. So among these changes in law, we have now what Lawrence mentioned. There is a reduction on the cap. Unless you are a small property owner, that's someone who owns no more than 4 units, no more than 2 buildings, and is a natural person, not like a REIT or other real estate fund. You can only have 1 month's rent on deposit for unfurnished, 2 months for furnished. That's the maximum amount you can keep on account. And that is however you want to label it, call it pet deposit, call it last month's rent. Those labels are irrelevant. If it's not payment of rent for the next month that is coming due, it is most likely deposit. You're capped at 1 month. Going forward, and these are all new tenancies as of July 1st of this year, but you should start taking pictures now. You should take before pictures. If you want to deduct for this damage above normal wear and tear, you need to have the before pictures showing what the condition was like before. You need pictures of the damage showing what it looked like after the tenant vacated to show that it was damage above wear and tear. And you need a third set of pictures, which is you need to actually fix it to show you did the work. You need to send all those pictures to the tenants, or else you are not able to use this self-help fund. And I say self-help, again, you may still have the claims, but if you want to deduct from the security deposit and avoid the transaction costs of litigation, this is now a requirement. This change in law also enhanced the protection for professional cleaning, carpet cleaning, things like that. Again, the security deposit fund is not an offset. It's not an extra source of profit. If it is reasonably necessary to restore the condition of the property in terms of cleanliness to what it was when you leased it, they just messed the place up and didn't clean it on the way out the door, and there's a stain on that carpet. Okay, then you can deduct the cost of a professional cleaning service, but you don't just do it by policy and then deduct. And then the last change, this one, I think it's important that this is there. It's designed to protect service members in the military. And what it says is if you have an advertised rate or a policy of requiring a certain deposit amount, and you want to take more deposit from a service member based on, let's say, their credit score or something like that, credit history, you have to give them a written reason why you're collecting the higher amount, and then you have to basically give it back and reduce it to your normal standard amount if they are in good standing, timely payment of rent for 6 months. Maybe there are jurisdictions where this makes sense, but if most property owners are capped at 1 month's rent right now, I don't know why it would make sense to have a policy of less than that. But if you do have that policy and you have a service member applicant, this is now a new rule that applies to that. And I'm going to talk about an evergreen regulation. If I may, keep in mind, you owe interest on deposit. It's pretty high this year. I'm not 100% confident on the number. I think it's something like 5%. And that number I think is interesting because that's what San Francisco used to require when it was totally divorced from the actual prevailing bank rates that you could get. And there was a lawsuit, I think in Los Angeles, over the same thing down there. And it was determined that you could not, that a city could not require a landlord to basically give tenants a profit source on this. So that became the law of the land. I think San Francisco saw that was the way the wind was blowing and changed the regulation to follow suit. But suffice it to say, this is now, I think, a market-based rate that is just pretty high. I'm hearing anecdotally landlords can't even find a savings account that provides that level of interest. So, individual results may vary, but you need to be accounting for that interest. Although there is a rent board fee and the landlord bears half of it, and they can pass through the tenant's half of the rent board fee and deduct it from the security deposit interest rate. So it makes sense. Obviously pay the rent board fee, that's the law, but it makes sense to offset the security deposit interest. And I think it's good practice to itemize it every year like you're supposed to, and just let the tenant know this is the interest rate, this is what I will owe you on the deposit, and I am now offsetting the rent board fee.
Uh, uh, you know, Justin always has so many great tidbits that a lot of people just don't know about. And so security
Cut me
deposit
off if I'm
interest
talking too long, by the way.
comes up all the time. I have these conversations with potential clients, and their jaws drop when they think about what security deposit interest. I haven't done that at all. And I said, well, it is a local law. When in Rome, you should do as Romans do. And so in San Francisco, you have to pay security deposit interest. Outside the city, you have to check with your local jurisdiction. But in San Francisco, you definitely have to pay it. That's something that we do for our clients. But it is something that a lot of people don't know about. It's surprising how many people don't know about it. It is published by the rent board what the security deposit interest was at each year. And so definitely access sfrb.org or .com, I can't remember which one, and you'll be able to get
Right.
that information as well as like the allowable rental increase amount and the rent board fee amount that is charged every single year. And so that changes. All three of them change every single year, and they get published every single year. A couple other things I want to make sure I hit home on that Justin brought up. Um, Pet deposit, storage deposit, parking deposit, even if you hold a deposit for a garage remote, all those things are security deposit. As Justin said, they're not different. You can't add on it and then have more than 1 month's rent. They're all encapsulated in the same thing. It's a security deposit. It doesn't change just because you decide to call it something different. Just remember that because charging anything more or collecting more than a month is going to be illegal from that perspective. And then normal wear and tear. It's something that we have conversations with owners all the time. Hey, why didn't we collect a security deposit on this? Well, the reality is it's not beyond or it's within normal wear and tear. We only charge if it's beyond normal wear and tear. So if you have scuff marks on the wall, that's normal. If you have nail holes from paintings and pictures and portraits that people put up, I mean, that's normal, just like you have at home. You can't charge for that. Now, if somebody has a fist punch hole through the wall, that is beyond normal wear and tear, and that's what you charge for, right? Those are the types of things. But deterioration of grout in a shower tile and things like that, you can't charge for. That's normal par for the course. The rent that you get every single month is supposed to pay for those types of things. You're going to have deferred maintenance, and that's what we have to pay for as part of the rent that comes in, but we can't deduct it from security deposit. Some other things are really important that I have a personal experience from, as well as having conversations with owners and being in front of a judge. You really need to pay attention to security deposit laws. If you mess up or misstep even once and you are brought to small claims court, they will not let you take any security deposit. You'll just lose everything. And that's if you don't provide a disposition within 21 days. If you don't have all the photos before and after, like Justin was talking about for the new law change that happened this year, if you don't offer the resident opportunity to do a pre-move out inspection and give them a opportunity to correct things so that it doesn't get deducted, if you don't provide them that opportunity, you could lose out on your security deposit as well. So those are all things that you have to be aware of. So just keep that in mind. You have any questions? Justin's information will be at the end, and so will ours. But
And if I can add to
getting
that
on,
also,
yeah.
oh, just briefly, of course, Lawrence is absolutely right about the perils of overstepping the line here and getting taken to small claims court. And you would be getting off easy if there was a big dispute with a tenant and all they did was bring you to small claims court. There is a $12,500 jurisdictional limit, meaning if they file and litigate a more expensive claim there, the most they can get is $12,500, and there's no attorneys, so there's no attorney's fees, generally speaking. Often enough, though, if there is already a contentious relationship with a tenant, they are already vacating, and now there's a dispute over security deposit, and they go seek counsel about what to do about it. Well, that counsel probably is going to run them through a quick little checklist and see what other things were wrong. And now, even though that tenant probably vacated because they were in a 1 bedroom and now they need a 2 bedroom, well, wouldn't it be interesting if they just put allegations in a complaint that the real reason they vacated is because the landlord didn't fix that thing and yelled at them them that one time and didn't return the deposit. And now all of a sudden, this is a wrongful eviction complaint where the damages arguably, if you improperly displace a tenant, the measure of damages they want are the difference between what they were paying, market rate for a new unit, comparable one. They take that spread, the rental rate delta, that gets present valued for the number of months they testify they lived there, and then it gets tripled and they get attorney's fees. That's a plain vanilla wrongful eviction lawsuit, and they're terrifying because they are factual disputes. You have to litigate in front of a jury whether you did something in good faith or not. So with security deposit, I mean, that's a canary in a coal mine with all this stuff, as Lawrence is saying. Stay on the right side of these issues and stay so far on the right side of these issues that there can't be a reasonable factual dispute.
Not to get down into a rabbit hole, but if you're paying property tax or you're going out to eat and you're paying sales tax or you're buying something in San Francisco, all of that is going to the general fund, and San Francisco provides free legal services for tenants. If you didn't know this, they do. And so tenants don't have to pay for a lawyer. They get a lawyer for free. And so that's what we're faced with as property owners in San Francisco. And so that's why you see so many people opting not to manage it on their own, because there really is so much risk. It doesn't make sense for you to try to collect 3,000, 4,000, 5,000 a month if you lose all of that in a lawsuit just because you misstepped. So be careful out there. The next thing that happened in 2025, effective beginning of this year, was Assembly Bill 2493 around rental applications, tenant screening. And so this is something that really surprised us as a property management company. Is something that we have to deal with. And if you are charging application fees, you really need to pay attention here and know what you should or should not be doing when it comes to collecting application fees. So what's going on, Justin?
So there are, in theory, costs with making sure that the tenant that applies for your unit is a qualified tenant. And when we say qualified tenant, this kind of question, this inquiry or this stage of leasing, it's fair housing law. There are other regulations that affect it, but the one that is maybe most core to this is the Fair Employment and Housing Act in California, which has a long list of suspect classes. And this could be things like race, gender, gender identity, preference, national origin. It has expanded recently to things like if they're a Section 8 voucher holder, that is a category on equal footing and is equally protected. So when we're talking about screening people for their qualifications to be tenants, we're talking about neutral categories. So things like, do they have sufficient income so that they can cover the monthly rental payment and then some? A lot of people are using like 1/3 of the income going to rent. Do they have a history of eviction lawsuits, things like that? So these things would come up usually in a credit report, and credit reports cost money. You can charge an application fee to cover those costs. And for some larger property owners, or property managers, this can be a big monthly expense. Lawrence and I were talking about this at Professional Property Management Association, and for some, it's like thousands of dollars a month. And under a certain protocol in terms of collecting this fee, you could offset it. But the current version of this law gives you two policies to choose from if you want to actually charge the fee. You do not have to charge the fee, but if you're going to collect it from applicants, you elect one of these. Now, you need published criteria. So this is, what I was talking before. Obviously, the criteria is not going to be anything that violates the Fair Employment and Housing Act, but you have this lawful fair housing neutral criteria that is published, provided to the prospective tenants. You can either adopt the first qualified, first approved approach, and you can charge a fee to anyone. If they're not qualified, that's fine. You collect the fee, you process the application and determine that they were not qualified. And you can keep that fee, and you can keep the fee of the first one that you ran that was qualified. And that's fine. And you just don't charge anybody else, or if you charge the fee prospectively, you give it back within 7 days. And that first qualified applicant is the one that you offer the place to. The other method is you can collect it from everybody, but you just refund it to anyone you didn't end up selecting. Between the two, I think first qualified, first approved makes the most sense, because if you were, I have to inhabit this terrible mindset of thinking everyone's going to get sued for everything, and that's what I want to avoid for my clients and what we try to avoid as an industry. So what I'm thinking about is who's getting sued and for what. If you get sued and you have this published criteria and you have internal business records and you show this one, you actually ran the application, you charged the fee, you kept the fee, but they were disqualified because they didn't have sufficient monthly income. And then you asked for a cosigner and they said they couldn't get one. Great, that is a great business record. You denied them for a lawful reason. And then this is the first applicant. Maybe you were timestamping these things, and that's how you know who was first come, first served. Great, that's a good business record that shows, well, this one was qualified. They had sufficient income, no history of evictions. You're in. And I think that would successfully defend that lawsuit. But another approach here is, again, this regulation is just how to keep a fee and charge that fee. You don't have to charge the fee. And if you don't charge the fee, you don't need to have these published criteria, and you don't have potentially a personal injury lawyer looking at your criteria and saying, well, okay, maybe that one's not targeting a discriminatory class, but maybe it is, and maybe I want to file a lawsuit over that. We have been talking for years. I'm sure a lot of people listening in have heard about it, or maybe they know someone who's been a defendant in this lawsuit. But I mentioned Section 8 vouchers. Are a protected voucher holders are a protected class under FEHA, and there have been shoppers who will just call up or email or go through a Zillow portal or something like that. Do you take Section 8? And if the answer is no, they are now a defendant in a lawsuit. So these lawsuits, they can happen. Again, if they're factual disputes, unfortunately, you might be litigating on the merits with significant legal fees, or as the personal injury attorney probably prefers, you're just paying the nuisance value of the lawsuit to get out of it. But the more you can have these internal business records, the more you can avoid having published criteria that someone can scrutinize, but you're still in compliance with the fair housing aspects. I think that's qualitatively better. This one's a business decision, though. If it makes sense for you, especially if you're doing this at volume and this is a big monthly expense and you want to keep the fee to offset the applications you're actually running, you do need to choose one of these two options, and you should have published criteria.
It's funny that Justin mentions the testers out there. We call them testers. But I remember when I was just self-managing my own properties and I would get calls about Section 8. And I've always been partial to Section 8. I've never had any problems with them. The housing authority themselves may be a little slow and a little delayed in the responses, but the rent is guaranteed. And most of the Section 8 renters we have, and we have a few dozen out there in our portfolio, they keep the properties clean because they have to be inspected on an annual basis. And if they aren't kept up to par, they really risk losing their voucher. And these renters don't want to lose that voucher. That voucher is very, very valuable for them. So don't, I'm not here to advocate for Section 8, but don't dismiss it. And technically you can. It's a protected class, a source of income. What I will say is that source of income is not just Section 8. There are a lot of subsidy programs out there for the city and county of San Francisco. San Francisco Housing Coalition, Abode is another one that is very popular right now, and we accept them from all those NGOs as well as government organizations. The other thing that Justin brought up was published criteria. I just want to touch on this. As a property management company, we have to have criteria. As a landlord and self-managing, you should have criteria. You have to make things objective. It has to be black and white. You do not want to make things subjective. Once you start making things subjective, that's when you really start to get in trouble. That's really when you start to expose yourself to a potential discrimination lawsuit. So just be careful out there. I know a lot of you like to lease it up on your own because the leasing fee out there might be expensive, right? It could be a 1 month's rent or it, something close to 1 month's rent. But that 1 month's rent is worth it instead of having a lawsuit, because at last count, and I'm not keeping count, but I think I heard it on the last SFAA meeting, 30 something protected classes. I can't even keep up anymore. There's just so many at the local level that San Francisco keeps on pushing out that a lot of people just don't know about. And you make a mistake, you're really inviting yourself to a lawsuit. So just be careful when you're trying to lease up properties on your own. Be careful what you publish in terms of your marketing, and be careful what you say to prospective applicants when you meet with them. Any of those things could really introduce you to some trouble. So definitely be careful out there. Something that just popped in my head that I know um, is kind of relevant to the application screening process that I want to make sure that you landlords out there know about is credit scores. Can you include them? Absolutely. There was a law that changed, and I'll let Justin chime in on it. And it's credit scores when it comes to, and I'm sorry I'm throwing Justin a curveball on this because it just popped in my head, but credit scores for like uh, Section 8 recipients, right? You can't include that in your criteria. You have to keep that in mind. What you could do if you want to be more selective, especially in light of these new changes, you can say, I'm only accepting credit scores of 750 or more. And that could be a criteria that allows you to be ultra selective. It doesn't mean that you can't look at a lot of different applications. A lot of applications might not qualify if you have a higher criteria. If you make it, 4
I'm
months
gonna
or
take a more conservative and concerned approach to this. I think that would have been fine until, so this is SB 267, I think. I believe it was the 2013 legislative year. Um, that would have been fine. I think the problem now is in the specific case, and you're right, it's not just Section 8, it's governmental subsidies. Generally is included in this broader description of source of income, which is the new protected class. But a recent change in law says that if the holder of a government subsidy does not have a sufficient credit score or otherwise doesn't meet these criteria, you have to allow them to provide other documentation that shows that they can be qualified. So this is one of the things I'm concerned about, and it's so treacherous, right? Because that would otherwise be a pretty neutral thing to say, but if it's proxy, unless it comes with an asterisk saying, unless you have a government subsidy source of income, then let's talk. So even that, so one of the other things you mentioned though, I think you're absolutely right. Have these published, sorry, not published, have these criteria, have them documented. The question of whether they're published or not is really just a question of how easy it is for someone to peek under the hood and see what they may want to try to file a lawsuit over. But at the very least, you should have them internally. You should document these things internally. Put it in your property management software. This caller called in and asked, do we take Section 8? I responded, yes. And when would you like to see the property? And they did not leave contact information. Whatever you have that is documented as part of your regular practice, that becomes a business record. That means that if you do get sued, your lawyer can step in and say, well, this is what happened. These are the facts. It is otherwise hearsay and not admissible unless it is, there's all kinds of exceptions, but we say this is a business record. Or how do I know that I did it this time? Because I always do it this way. Therefore, I would have done it in conformity that time. So these kinds of things, these kinds of protocols, as Lawrence mentioned, that they're important on their own 2 feet, but this is another reason because they help back you up when you are defending your practices, your otherwise lawful practices.
Yeah, and that's exactly the same reason why when the law clients ask us, "Hey, can we be involved in the application screening process?" We thank them kindly for wanting to be involved, but we highly recommend and tell them no, no, thank you, because we don't want them to make a mistake, and we rather keep them at arm's length because we're trying to protect them. And that's what you need to do. You need to be careful with what's out there. Uh, we absolutely provide a rental resume package for them so they know who's going to be living in their property, but we don't want them making decisions because if we had to test them on all 30 plus protected classes, I'm sure they wouldn't be able to get all of them correct. I know we still have a few more items to talk about. So we're getting into things around domestic violence protections, and Senate Bill 1051, effective this year, around domestic violence is really relevant. And I want to touch a little bit broader on just breaking leases. there's a lot of reasons why somebody can break a lease. I'll let Justin correct me if I'm wrong, but I know like for service individuals, if they get recalled to duty, they're allowed to break a lease. If you have to relocate for work beyond a certain number of miles, they're allowed to break a lease. So uh, just remember, there are reasons why somebody can break a lease. In the cases where they can't break a lease, they still can move out. They just will be responsible for rent until you can find a replacement renter. But just keep in mind that you actually have to, in good faith, try to find a replacement renter. You just can't sit on your hands and collect rent from them. So keep those things in mind. But for the domestic violence protection, that is one thing that came up this year. And so Justin can give us a little bit more color on that.
So a lot of what I'm just going to touch on this briefly because there's a lot of different procedures and substantive laws that intersect here. And this just kind of fine-tuned some of it. So I'll just say generally, domestic violence, unfortunately, it happens. Sometimes it happens between two people who are co-tenants on the lease and they're living together. It could be a married couple or just people in a relationship, or maybe even just roommates. Or sometimes it could be someone who has a significant other that they're bringing over. When this is multifamily, multi-unit property, the problem is compounded because it's not just someone having a dispute in their own private home that they're renting. It is their dispute which erupts into loud arguments in the middle of the night, or slamming doors, or someone pounding on a door. Take me back, you'll never find someone else, like, I don't know, whatever. But now it's affecting other people in the building also, and you have a duty to protect them, to preserve their quiet enjoyment of their own unit. That's when the obligation gets thrust upon you. So at the local level, this would be a species of nuisance. It would be just cause for eviction. But if it is multiple people in the unit and they're causing a problem, the court will actually evaluate who the dominant aggressor is, and you can evict just that person and keep the other person there. I think this is the singular example that I can think of where you can file an eviction lawsuit and get a judgment for less than all of the occupants, just according to these state law procedures. What the changes in law want to do basically is make it easier for the tenant to get out, and that's, as Lawrence was saying, a lease break. Usually, if you are a tenant and you have this ongoing tenancy, you would serve 30 days notice to the landlord. It would end your tenancy. If you have a term lease, you don't get to break it other than by agreement. You're obligated for the rent, at least, subject to the landlord's duty to mitigate damages and try to release it. But for a victim of domestic abuse, they can provide 14 days notice as long as they provide documentation, and that can be things like a restraining order or something like that. And then they're allowed to provide that notice, leave early, and pay the prorated amount of rent. And then it is up to the landlord to relet it to be made whole on the rent obligation. These changes also broaden the class of people who are beneficiaries. Did I lose Lawrence, or did everyone lose me? Maybe someone, let's see, I see Kiop in the
I think,
chat, or,
yeah, I think they lost connection, but they will be back.
and I see Nathan. Is everyone else still there? I can't, if you can hear me talk right now. Hi, everybody. I don't know if you're there. I'll keep talking on this, right? Everyone's still there?
Yeah, they're still here.
Okay, well, thank you, and we'll get Lawrence back shortly, I'm assuming, but, oh, I see thumbs up. Thank you for the encouraging emojis. Okay, so this broadens the class to family members of people who are victims of domestic abuse. It allows the tenant to request that the landlord change locks at the landlord's expense to keep the tenant safe, or if the landlord's not timely responding, they can do it, and then the landlord has to compensate them for the cost of changing the lock. So this is just sort of a fine-tuning, a micro adjustment to pre-existing law designed to broaden the class and of beneficiaries of these protections and give them a little bit more protection. And I think we have Lawrence popping back in, and maybe still needs to be promoted to panelist.
Recording in
All right.
progress.
All right. Okay,
Sorry
welcome
about that.
back. We just got through domestic abuse.
All right,
And-
sorry about that. A little technical difficulties. Wi-Fi went down for just a bit. Now, thank you for providing some updates on that. It is something that we surprisingly and unfortunately are hearing a lot more about that. But the takeaway is there are definitely a lot of reasons why people break leases, and they do have the right to break a lease in certain situations. Domestic violence is one of those.
I think it's a technical difficulty, guys, so
Okay, well, while we're waiting for Lawrence, then there's a few questions in the chat. Maybe I'll field until he comes back. So, question: do you see rent control moving to single family dwellings? Most cities do not control. I'm assuming apply rent control to homes and condos. So this goes back to what I was saying when we were talking about Proposition 33 and the history of rent control. Before the state stepped in and adopted the Costa-Hawkins Rental Housing Act, the cities, California cities, had authority to do this as part of their what's called their police power. This is power reserved to cities by the California Constitution. So before Costa-Hawkins, rent control apply. I mean, if you look at it's section 37.2 subdivision r, rental unit. If you look at the definition of rental unit in San Francisco, it includes condos and single family dwellings. It's just that while Costa-Hawkins is state law, and with certain exceptions, it cannot apply. It is preempted. Those exceptions include things like if the tenant in a single family dwelling that was constructed before June 13, 1979, so it's not new construction exempt, if they were living there prior to 1996, which is the effective date of Costa-Hawkins, they're grandfathered in. Or if it's a condo where it was an existing apartment building that's been subdivided as opposed to new construction condos, and it has not been separately alienated to an owner occupier, it's technically not exempt under Costa-Hawkins yet. So that still would be subject to rent control. Lawrence, you back?
Yeah. All right. I am going to just use my phone because I don't trust the internet anymore. So my apologies for that. Must be the storms that we're having. But let me, so I think before I unfortunately got disconnected, I was talking about something that happened back about 10 years ago. There was a huge party in Berkeley. Students were having a little bit too much fun, and the balcony collapsed, and people died. And so this was something that not only happened in Berkeley, I think it happened in Chicago as well. But one thing that did happen as a result of that was San Francisco, progressive city that it is, wanted to make sure that this wasn't something that would happen in San Francisco. And so they passed a law quite a while ago where it started to require for any properties that were larger than 3 units or more to do a quinennial inspection. So an inspection every 5 years, and you actually had to file it with the building department, the results of that. And what it was you had to either have an architect, a general contractor, a structural engineer, somebody professional that could assess any exterior appendage. So it could be balcony, it could be a deck, it could be an exterior stairwell, any of those things. And the whole purpose obviously was to provide some more eyes on all these things that are out there and making sure that they were safe so that San Francisco wasn't on the headlines globally like Berkeley and Chicago were. More recently, at the state level, they passed that AB 2579, which I brought up earlier, which now requires it as well. And so that's just something, if you're not doing it already, the law now exists both at the state and as well as the local level. At the local level, it was called the 604 inspection. But if you search DBI and 604, you'll find a wealth of information online about it. If you are less than 3 units, I think you're exempt, but good practice just to have it looked at, because being in San Francisco, salt air, a lot of rain, dry rot, things can happen. And if you're not on top of it and you're not being proactive, you're really exposing yourself to some undue risk out there. The other thing that is more, and I'm not sure if I'm saying it correctly, procedural, but I'm going to let Justin talk about more, is around the eviction process and Assembly Bill 2347. and how that impacted the process around evictions and the timeline for that.
So as I mentioned earlier, there's this interplay. We were talking about the 10-day notice to cure. There's an interplay between state law procedures for unlawful detainers and local substantive controls over the basis for eviction. I mentioned also unlawful detainers are designed to be the fastest kind of civil litigation. All of the procedures are set at the state law. There's something called the unlawful detainer statutes, which are part of the broader code of civil procedure, and they are exceptions to the rules. And in fact, I remember it was almost 15 years ago, I was getting started in this industry. My then boss was saying I was going to learn civil procedure better than anyone because I was going to learn all the exceptions first. And I think that's pretty much been true. We see some pretty wacky stuff in unlawful detainer law. So how it was up until January 1st, you would have a 5-day summons. I'm going to go a little bit further back in history. It used to be a 3-day summons, 3 calendar days. I was interviewing Judge Garcia, who is now a mediator. He used to be the housing court judge in San Francisco. He's now a mediator at JAMS. We use him all the time. Very knowledgeable guy for these kinds of disputes. But I interviewed him for the SFAA magazine recently. He was telling me back in his day, it was a 3-day summons. The landlords would serve it on a Friday, and all the tenant attorneys would have to have an emergency Monday morning meeting every Monday to respond to the complaint before there was a default. That's probably unsportsmanlike, and sure enough, it was changed to a 5-day summons, and then it was changed to a 5-day summons, but you don't count weekends and judicial holidays. Well, now it's a 10-day summons, and you don't count weekends or judicial holidays. Now, the more and more this gets elongated, the less and less unlawful detainers start to look like a summary proceeding. And this is assuming you even serve the tenant. If they know the eviction's coming because they've already seen the eviction notice, maybe they just don't open their door. You need to go to court to get a posted mail order so you can actually serve the summons and complaint. Another unique circumstance for unlawful detainers, you can serve it by taping it on the door and mailing it to them if you have a court order. It's assumed that if they really are in possession of the property, they're going to find it. And that satisfies due process. But now we're a month into getting them served on something that should have taken a 5-day summons. So the more and more you stretch this out, the more and more the procedural rights of the landlord are taking a hit. But a compromise that CAA was able to advocate for, again, such an important group for this industry. The first thing that most tenants file, especially in San Francisco, is something called a demur. A demur is essentially an objection to the complaint saying, yeah, fine, I concede everything you just said, but you still don't state a claim. This should be dismissed. And because an unlawful detainer lawsuit is based on the proper service of a legally sufficient notice and its expiration with the tenant still in possession, I mean, it can be more fundamentally about breach of lease, nuisance, an owner move-in eviction, whatever. But when we're talking about the cause of action, we're talking about the expiration of a notice and unlawful holdover. You have to attach the notice to the complaint. And since the notice is a prerequisite to this lawsuit, if there's something defective about your notice, the whole lawsuit goes away. You start over. So tenants love demurring to the complaints. It used to be a 16 court day motion. So that took up about a month. And the more a tenant is in possession, they're not paying rent, the more they get free housing. Essentially, they get a tactical advantage when it comes time to a settlement discussion. So the compromise CAA got is instead of a 16 court day motion, it is now no less than 5 court days and no more than 7. So it dramatically reduces that timeline. CAA is advocating for property owners of all shapes and sizes throughout the state of California. And so for these property owners, this is really an unqualified victory in terms of timeline. Yes, it takes longer to serve them, but we get the case at issue, we get the answer, and the affirmative defense is sooner. The only person this really hurts is me, because someone's sitting on my eviction notice sometimes for an entire year, gets to concoct all sorts of things. I've had demurs on the basis of perceived violations of the corporations code and probate law if it's owned by a trust, and they get a year to write their demur, and I have to respond to it now in 5 court days. But don't worry, guys, I have plenty of coffee, and I can miss a couple nights sleep.
You know, Justin, you're in far more evictions than I am. I have far fewer that I'm involved in. And
I'm so happy to hear that. Good
but
for
one
you.
thing that I think really surprises landlords out there is how long it really takes. And so they have this unrealistic expectation that things can be done within weeks. And, you know, our most recent eviction that we had to deal with, where it was even as simple as a non-payment of rent, a lot of the back and forth, the courts always giving the tenant another opportunity, it stretches things out. And I think that last one, it must have lasted almost 2 or 3 months. I can't remember exactly. And obviously the owner was uh, super frustrated, and for good reason. Personally should have managed expectations a little bit better, but for our landlords out there and those that are self-managing, can you give them just an idea of, on average, how long are you seeing for some of these evictions? Something as simple as a non-payment of rent, which should be pretty fast.
Well, let's do some basic math and then let's throw it all away because it doesn't apply. So 3-day notice to pay rent or quit, that doesn't include weekends or judicial holidays, but what are we at, the 6th? So if I served it today, we get to count 7, 10, and 11 expires at the end of the day on the 11th. I have a cause of action for unlawful detainer on February 12th, a Wednesday. I file that, I get my now 10-day summons. I serve it later that day miraculously. So 13, 14, the 17th is a holiday, so I get the 18, 19, 20, 21, 24, 25, 26, 27. I think that's 10. So by the 27th, they have to file their answer or demur, or they're in default. Let's say they file an answer. Wow, they don't want to challenge the complaint. That's amazing. I immediately set the case for trial because it's now at issue, and I'm supposed to get my trial date. The statute says within 20 days, but the trial calendar is a Monday. So whenever the next Monday, we show up the Thursday before that. That's the settlement conference. Let's say 95% of these cases settle. And let's say you're nice enough as a landlord, you waive the past due rent. You don't expect them to pay holdover damages, and you give them a month to move out. And did we get all the way to the end of March, let's say? That's how it used to be. That almost never happens anymore. So you serve the 3-day notice to pay rent or quit. As I've mentioned a few times now, that's set by state law. San Francisco can't interfere with it, but that's an example of why they wanted to, just to elongate the time in possession. You get that 10-day summons, you get it out for service, but they're dodging service. You have to get a post and mail order. This is a perfunctory application, and if you do everything right in terms of submitting it, it's supposed to just be granted. The policy of, this is Department 501. It's Judge Charles F. Haynes is the presiding judge there for unlawful detainers. He is supported by staff attorney Olga Grikova, and if anyone's been in that department, especially for an ex parte calendar, you've met her tireless effort just making sure these cases get advanced, and of course all the clerks there really doing a great job, not taking a position on any of this stuff obviously, but just trying to make the law do what the law is supposed to do. They try to turn these post and mail applications around in 5 days. So add 5 days to that. Then you serve it. They're not deemed served until 10 days after posting, and then the 10 days for the summons. And that's 10 calendar days versus the 10 that don't have the weekends or judicial holidays. So we just ate up a month just trying to get them served with what used to be a 5-day summons. Now they file the response again. It's going to be a demur in most cases. And Lawrence, as you pointed out, last time I checked, which was a couple of years ago, Proposition F was a $17 million annual budget for free full scope tenant defense. I'm sure it's higher than that now. Every once in a while I do a sunshine request and maybe I'm due for another one. So they're going to get a free attorney who is going to try to paper the landlord to death. So that's a demur. Let's say that takes 10 to 15 calendar days to show up on the law in motion calendar. Hopefully the demur is overcome. If not, you're starting over, but it's overcome. So now they have, I think it's still 5 days to answer on the other end of that. Now the answer, and the answer is going to interpose denials to your allegations. You're not usually worried about that because you are in charge of your own facts. You know what evidence you need for that. Like my accounting shows that they didn't pay rent, and I can bring my process server and my property manager or my landlord to show that the notice was served and authenticate all that stuff. That's the basic case. But now the tenant has their affirmative defenses. Well, there were habitability defects and you knew about them, and that should reduce the amount of rent was due. There's all kinds of evictions. I'm just using non-payment as an example. So that affirmative defense, you'd want to serve discovery on that. You might want to conduct a deposition of the tenant. You might want to subpoena other witnesses. You know, they say that there were mold conditions that they complained about, and they got an industrial hygienist to go there and run spore samples. So you subpoena that and maybe depose the et cetera, et cetera. So the side quest of doing discovery, it really depends on the particular case, but you set it for trial. And like I said, that's supposed to be 20 days. It's about 2 months right now. And probably that, I want to use the word violate, lowercase v, probably violates state law. But the reason San Francisco does it is because they only have so many trial departments. They will take 30 cases at a time on each Monday morning trial calendar. And unfortunately, a lot of those cases are really just trailing. They're cases that reported, were tentatively settled, please kick us over a week. Department 501 has tried to institute policies that minimize this, like having one attorney per line instead of one guy with a handful of files in a banker's box. But suffice it to say, we're basically getting in for our trial date whenever the court has time for us. And most recently, that's been about 2 months instead of 20 days. And even with the lockout, I think my most recent judgment was sometime in mid-December, and we immediately got, so you get your eviction judgment, and that is not itself the ability to get the tenant out. The judgment gets you a writ of possession. You bring it across the street to the sheriff's office and city hall. They set an eviction date, and they're the ones that lock the tenant out, but you need them to actually post the notice and set a date. And we're in February now. I've been calling them and pestering them, and they have not set a date yet. So there's some delay there. That's a little unusual, but for whatever the reason is right now, that's some delay. And I think what Lawrence was talking about is what happens when the tenant who has already lost the lawsuit starts wanting to get stays of eviction for whatever exigent circumstances. Well, if they get those stays, they're supposed to pay, the court uses the word rent, it's not really rent at that point. But so, okay, fine, I pay a week's worth of rent and I get my stay. Well, you don't want the rent, especially 1 week's worth of rent controlled rent, and they're already defaulted and I already had to pay my lawyer. That doesn't do me any good, but legally speaking, technically it solves the problem of irreparable harm because here's your rent. By the way, if you've ever tried to get rent out of the court's accounting department, it takes more in legal fees than the rent in a lot of cases. So it is what it is. And sometimes these things will get trailed out. And I think if I had to put myself in the court's shoes, I think what they really want to have is integrity in their procedures and integrity in the result. Trial courts have a lot of discretion over a lot of things in trials, but they really don't like getting reversed in the court of appeal. That's a court of higher authority telling them that they did something wrong, and that's not a good feeling for a judge. So they really do, I think, spend a lot of time, a lot of effort making the right thing happen. And sometimes that creates delay, and sometimes that's frustrating for the landlord. But as Lawrence said, if you're a property manager, you set your client's expectations. And long gone are the days where where property managers who maybe were trying to be on the opportunistic side brought evictions for trivial breaches or nuisances that maybe could be curable or reformed. And there was a big push in the last business cycle, peaked in 2015. So imagine all the lawsuits leading to that to try to use a fault-based eviction to get rid of a tenant so they can charge market rate rent or move into the unit without complying with the owner move-in procedures or whatever. Those days are gone. Rental property is increasingly drifting into the realm of a commodity, and you can own it, but that just means your name is on it. So really, when we talk about just cause, we mean that we have developed a long paper trail and we are in court and we get to tell a jury, I didn't want to be here either. I'm here because I had no other choice. I gave this person every opportunity. Hey, I noticed you didn't pay rent this month. Is there a problem? Okay, oh, you don't have it. Well, how soon do you think you could get caught up? And you have these kinds of paper trails. By the way, you didn't withhold rent because there's something wrong with the unit, did you? Because I'd love to get in there and fix it. You need to be on perfect behavior, and basically the tenant can raise 30 affirmative defenses and they only need to be right on one of them. So the process is longer than it has been historically, but we just try to implement best practices at every level. We make sure our notices to pay rent or quit or any other kind of eviction notice is perfect. That's the standard, strict compliance standard. If there's anything perceived wrong with it on any level, in theory, the court throws it out and you start over. So that's why we have meetings like this. It's why, I have my own meetings with every other landlord attorney in town. We just met on yesterday. In fact, we meet first Wednesdays of the month and we compare notes and we make sure that we were operating to the highest standard because that's what the law requires and that's what you guys deserve.
Well, bottom line, it's not easy being a self-managing landlord out there. And you need people like Justin and his law firm to really help you navigate all this because you can't do it on your own. Don't try to serve an unlawful detainer on your own. Don't try and serve a pay or quit on your own. Have a professional do it, because if you mess up, you get sent to the starting line again. You have to do it all over again. You lose more and more time. And so it does take a lot of time. And so in San Francisco, it's not about trying to regain possession. It's about trying to work with renters on seeing what you could do to have them keep on paying rent, because the alternative is months before you might even get possession. So I know we're already way past time, so I'm going to try to wrap this up really, really fast. There was a law that we skipped. It's around positive rent payment reporting. It is more relevant for larger buildings, not as relevant for small landlords, but it is a new law that changed. We're not going to get into it. It will be in the slide deck. And if you have more questions, you can definitely reach out to Justin. The reason I'm bringing it up is a segue. One of the best tools that we have for navigating everything in San Francisco is the San Francisco Apartment Association. The San Francisco Apartment Association is by far the best resource that we have as property management companies, as landlords, as property owners, to know what we should or should not be doing. They have monthly legal panels where you learn a wealth of information. One of the things that we use, and you should be using as well, is a lease agreement that's issued and authored by the San Francisco Apartment Association. Every single year, they update the lease agreement to include all the changes that have taken place, both at the state level, all the things that we talked about at the local level as well, and incorporates all those into the lease agreement. They even, like Justin was saying, they meet all the time. They compare notes. They try and find out what are the things that people are complaining about? What are the challenges for landlords? How can we make it more black and white? So it's in the lease agreement. And they incorporate all those recommendations into the lease agreement for you to be able to use. You can get that lease agreement by going to the ssfaa.org website. You can also become a member of ssfaa.org because it's so powerful, especially if you own property and you're a landlord in the city. So we're going to share some information on that with you, so you have that. The reason I segued into that is because in that SFAA lease agreement that is new this year, at the very end, they include addendums and notices around the rent payment reporting. And so you can read about the details on that as well in there, as well as a litany of other changes that took place and they incorporated it into the SFAA lease agreement. I do want to make sure that we cover a few questions that came up. One question I'm going to bring to the front of the queue is something that we talked about around security deposits. It's something that an owner asked me and other landlords or self-managing property owners was, well, I don't have the before pictures. I might not even have a move-in inspection to begin with. That's a problem. But if I don't have the property pictures of the condition of the property beforehand, what am I to do? And so I think Justin can share a little bit more about that.
Yeah, so generally speaking, laws do not apply retroactively, and obviously, if you have an existing tenancy, you can't expect the impossible here. So, trying to scan for the dates right now. I believe if you have a tenancy that starts on or after April 1st of this year, you would take photographs. There's no reason not to start that practice immediately for any new listings from now going forward. But that's when you'd need to have the before pictures. If it's a pre-existing tenancy, obviously you can't do anything about it. So you would just need the second two sets of pictures I'm talking about, which is the mini after, the ones that show the damage, and then the after the ones that show that the damage has been restored.
Great. And I'm going to have Justin look at the subsequent questions because I'm on my phone and for some reason I can't pull up the questions. Oh, there they are. Q&As. Here we go. So there is a question from, I own one property, 2 houses on a lot. Can I ask for 2 months deposit? Did I understand you to say I have to rent to Section 8 applicants? And so there's two different questions. The first one is about the property, 2 houses on lot, can ask for 2 months deposit. And it sounds like it's a really boils down to 2 unit on 1 lot. And so can she ask for 2 months deposit?
So the small property owner exception to this new rule, so again, general rule, only 1 month rent, exception for small property owners, you can have up to 2 months rent as a security deposit, requires that the landlord is a natural person and that the landlord owns no more than 2 residential rental properties that collectively include no more than 4 dwelling units offered for rent. When it says 2 residential rental properties, that's not really a term of art. I think the concept there is it means that if you own multiple lots that have residential properties on them, that you have a portfolio now that puts you into this realm of higher level of compliance. It's really not clear from the statute though. So if you wanted to err on the side of caution, I would say 1 unit. The idea that you just have 2 detached freestanding structures on a single lot, to me would read more like a single residential property. But if you wanted to take a literal reading of this kind of vague terminology, that starts to look like 2. So probably to err on the safe side. And this is another thing, by the way, this is not retroactive. If you have a pre-existing tenancy and you've collected more than 1 month's rent, you don't need to return the difference. But for any new tenancies, to err on the side of caution, you would just collect 1 month. Oh, and the next question, yes, you understood correctly that you have to rent to Section 8 applicants. Now, that does not mean if you have an applicant who is a Section 8 voucher holder and you have other qualified applicants that you cannot make a determination on which applicant you think is most qualified. It just means that you cannot exclude someone on the basis of the Section 8 voucher.
Yes. Protected class, source of income. Source of income, alimony, child support, retirement income, and any government subsidy or nonprofit subsidy would be source of income. Another question around domestic violence. I have a couple living in my unit. She has come to me asking to be taken off the lease due to domestic violence. She couldn't afford to pay the rent on her own. Can I evict her boyfriend for that violence after I let her out of the lease?
So I made some comment earlier, I think that generally the fault-based eviction notices are 3 days. They're not all the same 3-day notice though. Breach of lease, including non-payment of rent, that's a 3-day notice to pay rent or quit. Nuisance is its own creature though. And unlike the other ones, so if you serve a 3-day notice to pay rent or quit and it's not timely cured, the way the statute reads, the tenant is guilty of unlawful detainer if they have not cured it or vacated the property. Nuisance is a little different. It says the tenant is guilty of unlawful detainer, and if you serve a notice that is 3 days, not including weekends or judicial holidays, then you can file your lawsuit. That's when your cause of action accrues. But the nuisance occurred earlier. The tenancy is already in forfeiture for their fault-based action at that point, and now you are just getting ready to file the lawsuit. What that means is it is not curable. And when you're litigating nuisance, part of that proof up is not that you gave them an opportunity to cure and they didn't cure. Does domestic abuse here amount to the level of nuisance? That's a fact-based inquiry. And again, I say you're going to want to see, I don't mean want like you want the domestic violence. It's terrible when it happens. And to thrust you in the middle of having to be the peacekeeper, not only for the tenants, but also the other tenants, it's a very frustrating process. But it's happened, it's bothering the other tenants. Let's say if you think it amounts to the level of nuisance, then you would serve that eviction notice and you litigate. And like I said, this is the rare example where if you have the right facts for it, you litigate, you evict the dominant aggressor and you keep the other person in possession. But if this is a tenant, I guess, is this the girlfriend who wants to leave, can't pay rent on her own, but leaves the boyfriend behind? So a couple things are intersecting here. Do you let a rent liable co-tenant on the lease off the lease so that they're not obligated to pay the rent? Well, that's a choice that you can make. Sorry, my office lights just went out a little bit there. That's a choice you can make. It's entirely up to you. If you let her off the lease and you do not consider her rent liable and the rent comes due and you serve the rent demand to the boyfriend and he doesn't pay it, well, now you have a non-payment of rent eviction. If the source of the nuisance, again, different just cause for eviction, if the source of the nuisance is abated because she left and you let her off the hook, you're not really under any obligation to do it, but if I'm looking at this messy situation and it gets resolved because she wants to leave and all she needs is for you to let her off the lease and the boyfriend will otherwise behave himself and you don't have to litigate any of these issues and he finds a way to pay the rent, it's a victory. It's a qualified victory, but at least it solves the problem and no one is the victim of domestic abuse here and everyone's paying their rent. So with these problems, you know, in this example, we talked about 2 hypothetical just causes for eviction here, but there's a lot of messy facts. You want to approach these problems holistically. You want to have an eye towards doing what you can to keep tenants in their units, because that is the underlying policy of all of these laws. They don't want landlords to recover units whenever it's most profitable. They don't want it to be, I say they, the government, the state of California and San Francisco. It's to keep tenants in their rental housing for so long as they want to stay there and for so long as they are in good standing. So whatever you can do to mitigate the issues here, to protect your other tenants and to solve the problem, you know, to get involved in this little private dispute and mediate it, whatever you can do to keep the peace and keep the rent coming in and no one is having loud arguments in the middle of the night, that's a win.
All right. And last question was, it looks like it was answered live, but I want to make sure that I bring it up for everybody that is still online. Do you see rent control moving to single family dwellings? Most cities do not control homes and condos. And so I will say that there is a statewide law, AB 1482, around not only rent control, but eviction control. And so there are exemptions, and single family homes and condos in certain situations can be exempted as long as they're not owned. And you can look into the exemptions on your own, or you can reach out to Justin or myself. But there are exemptions or exceptions to that, I should say. And you know, let's hear Justin. I mean, it right now it's protected, right? We have Costa Hawkins, but at the end of the day, anything's possible. Laws change all the time, so it's possible in the future, or even the near future, it might change.
So I think that I touched on this briefly while we had some connectivity issues, and I was talking about how at the local level, literally speaking, yeah, they are regulated. They're part of the definition of rental unit, just like multi-unit buildings. Costa Hawkins is what is currently keeping them from being subject to those regulations, although I did not touch on your point, AB 1482. This is statewide rent cap for, you know, say you're in a non-rent controlled jurisdiction. The law of the land now in California is you can increase the rent no more than 10% or 5% plus that year's CPI, whatever is less. That is your annual limit. And if it's more than 10%, it's a 90-day notice instead of a 30-day notice. Exemptions to that for natural persons, and you serve your AB 1482 exemption. But I think an open question is, what happens when you are talking about a unit that is otherwise covered by a local rent control ordinance, but for Costa Hawkins at the state level that exempts it? And let's say you have a single family home, but let's say it was a pre-1996 tenancy, so it's grandfathered in, notwithstanding Costa Hawkins, and suddenly the last original occupant vacates, but they leave behind a post-95 subtenant who is not protected by rent control. And you're telling me that I get a one-time rent increase here and I am limited to AB 1482. I don't think that's correct. I think when you have a bona fide vacancy decontrol unit, AB 1482 can't apply. The logic of that just doesn't make any sense, because Costa Hawkins literally says, notwithstanding any other provision of law, these are the rules. And it doesn't mean just local law, it also means co-equal state law. So this is just a gray area. In other words, the question of when does AB 1482 statewide rent cap step in when local authority does not regulate a unit, and that could apply to a single family home in certain circumstances, or frankly, even new construction. It's a question that is potentially going to get resolved in the Court of Appeal if and when it comes up. This law currently sunsets in 2030, so if you can hold tight for 5 more years, it might not matter. But it's just kind of a gray area. So I think you'd consult with an attorney who'd give you an evaluation on a case-by-case basis.
Okay. I want to leave you guys with one nugget before we share everybody's information, SFAA information as well. And that's with rent increases. This is something that KIOP does. I don't think Justin knows this. But for us, we don't raise rent beyond 10%. And there's a reason why. State law requires that if you raise the rent 10% or more, you need 90 days. But the problem is at a in California, we have so many problems. We have wildfires, we have these atmospheric rivers, and you're probably wondering, where are you going with this? Well, the reality is the governor will issue an emergency declaration. And once he issues an emergency declaration, then there's these price gouging laws that come into place, and you can't raise rent more than 10%. And so the problem is these emergency declarations happen all the time. Windstorms, rainstorms, fire storms. And so you might be 89 days into your notice period and emergency declaration comes into play. And now your 90-day notice was a waste. You just wasted 3 months. And so what we do is we don't increase more than 9.9%. We recommend looking into that, maybe following that same thing. Just realize what you can increase, what's the allowable amount, regardless of whether you have a single family home or something that's exempt from rent control. So that's a little nugget for you guys. Can we share the SFA information for our attendees? So Maria Shea is the membership coordinator. She's also one, if you're interested in anything around SFAA or the lease agreement membership, she's the best person to contact. Can't say enough great things about SFAA. We would not be an effective property management company if we didn't have SFAA and we didn't have lawyers like Justin who are gracious with their time and provide Q&A and legal panels on a monthly basis. And let's share information for Justin as well. Please screenshot these. That way you guys are able to have the information later. They will be in the slide deck that we send to everybody at the conclusion of this webinar as well. And I think we need to forward a couple slides so we can get Justin's information up there. I will say, you are lucky to have Justin's personal information. He is a very busy man, and so he might not be able to respond to you, but he will have his assistant respond to you. That way he can find out exactly what you need. There is some administrative things as well in terms of conflict checks and things like that and getting the right information. So if you do need help, he is more than happy to help you, but have to get through the administrative items. Now for the slide deck, if we could move forward to the next slide, take a screenshot of this, scan it with your phone. We'll be able to get your information so we can send you the slide deck. If you're on an iPhone, you can do the 3D press on the photo itself that you screenshot to actually go to the QR code as well if you aren't familiar with how to just use the camera and scan the QR code. All right. I do want to, again, express my deepest gratitude for Justin and his time to graciously share all his expertise and his knowledge around landlord-tenant law. We would not be able to host this seminar without him. And yeah, Justin, any parting words?
Just, it's, of course, always a pleasure to see you and spend some time with you doing this for the community. And thank you for having me.
All right. Take care, everybody. Stay warm, safe, and dry out there.
Bye, guys.